Ladies and gentlemen, thank you very much indeed for coming along this evening to the College Chambers seminar on family law arbitration. Now, first of all, ask whether everyone's happy to be filmed from the back. The reason being is this is going to go on our webinar, so we can put it on our website and disseminate it a little further. I take that as a yes, thank you very much indeed. Simon and I are going to be talking to you this evening about family law arbitration, and in keeping with the procedure which family law arbitration is going to involve, which is as consensual and as user-friendly as possible, please feel free to interrupt us at any point and ask anything that occurs to you at an appropriate moment. So this is more discursive than us simply declaiming to you. When Simon and I finished our case, or towards the end of our case today in Portsmouth, we told the judge that we were both going to Southampton to give a lecture on family law arbitration. He said, "Oh, good, excellent. I'm all in favour of family mediation. Why wasn't it done in this case?" And we said, "No, actually, sir, it is not mediation. This is arbitration, and that's completely different." And that's a sort of misconception which I think may be fairly prevalent, but it shouldn't be amongst the higher judiciary because they've all been told about it. This is not about mediation. You'll all know about family mediation. Family arbitration is something completely different. And those of you who've practiced general civil law in the past, or may even do so now, as well as family law, will think in terms of arbitration of complex civil disputes and really rather arcane areas of the Chancery Division of the High Court. So I'm going to begin by talking to you about what a traditional use of arbitration really is. It's pretty simple, really. When any two or sometimes three parties have some form of dispute which they can't resolve between themselves, they'll appoint, or they may appoint, a third person to resolve that for them. And that's it. That's an arbitration. The third person will assess the relative merits of the two cases on either side and come to a decision. And the parties who are in dispute have agreed to be bound by that. And that really is the fundamental of an arbitration, which is an agreement to be bound by the decision of a third party. And I'm going to skip through with you the reasons why parties may choose an arbitration and what the parties really want from an arbitration. If you could just press the down button, Mark, and you'll see a nice picture of a bowl of fruit. And the reason why I put that there is one of the traditional uses of arbitration is to resolve disputes where you need a quick decision. For example, traditionally you may have a dispute about the importation of fruit on the high seas, and it's not much use spending 18 months litigating in the High Court until you get a decision from the judge, because by that time the fruit's all gone rotten. You want someone to make a decision and you want it done now. And in family law arbitration, that would be one of the features which we hope to be able to bring to the law. Speedy decision making. Can you move the cursor down, Mark, please? This is probably what you think of in terms of arbitration. Complicated building and construction disputes with detailed issues of fact, schedules of works, counter schedules, expert witnesses, surveyors and architects. And that certainly is how arbitration traditionally has been characterised. And it may be also in family law arbitration as well, when you have complicated issues of fact which you want to break down into little sections, rather as you might do in a Scots schedule in a building dispute. So we think would be particularly suitable for family law cases in which the disputes go wider than simply the dispute between the husband and the wife or the claiming beneficiary, but there are issues of businesses and so forth which have to be unscrambled as part of the decision making process. Can you move it down, please, Mark? Specialist tribunal and use of jargon. And I put a picture of a laptop there to illustrate really what I mean. One of the reasons parties traditionally will have used arbitration is because you want somebody deciding the case who actually knows what he's talking about and what you're talking about, and avoid those who are the Beatles moments, which happen less frequently in the courts but still do happen from time to time and particularly where you have to try to explain to a district judge specialist material, such as, for example, the way in which the IT industry is working at the present time, because it's material to one or other of the parties' employment prospects or their ability to support themselves. Arbitration is also extremely useful where confidentiality is a major issue. The picture of the dentist and the patient in the chair are derived from the last civil arbitration I did as counsel, in fact, which was a dispute between a dentist's practice, the partners in a dentist practice, who needed to resolve their matter in a way which did not involve going through the courts for a variety of reasons, but mainly because, of course, it's extremely sensitive to have your partnership dispute dragged out in the local county court, because if you're in business with somebody and that becomes public knowledge, clearly it is damaging for the business. Again, in family law, of course, you have a degree of anonymity in that your proceedings very often simply have the surname or even the initial in the county, initial in the court list. Nevertheless, there's a certain public face to having to attend at the court with your opponent on the other side and having to have that contested in a public court. So confidentiality may be a major issue to the parties. What do the parties really want? I thought it'd be nice to show you a picture of the Spice Girls, and it was a bit of a cheap joke really, but my daughter managed to get that onto the overhead, so I might as well use it. Well, if we're honest about it, what the parties really want is the decision maker to agree with them. But everybody knows that can't happen all the time, and everybody knows the decision maker is likely to agree partly with them and partly with the other side, and maybe not with them at all. So realistically, what the parties want is to select their decision maker if they can, a known quantity, somebody who will actually understand the case rather than taking pot luck, and you may come along to a court hearing and find that the person who's been appointed to hear the case had a specialist practice in tax law or crime or something else completely inappropriate before the hearing. Secondly, the continuity of the decision maker. That's something which we think that family law arbitrators can bring as an advantage to the case, because the same person will be making the decisions throughout. And as we'll be looking at in a moment, in, for example, family law arbitrations between husband and wife, there will only be usually 2 hearings. There won't be an FDR. There will simply be the first directions hearing and a final hearing. So you will cut out one element of it, and the reason for that we'll come to in a moment. Flexibility and choice in the proceedings. It's an important issue for the parties. We'll look, when we skip through the Arbitration Act in a moment, at that in a bit more detail. But the aim of arbitration is to give the parties as much control as possible over the proceedings. So, for example, arrangements may be made for all or part of the proceedings to take place in a room like this, or in the solicitor's office, or in our chambers. It means that there's access, ready access, to the arbitrator, the decision maker, in a way that there won't be for the judge, because the arbitrator will be providing the client with a service and is part of the discursive process with the clients. Efficiency. The aim of family arbitration is to be as efficient as possible and as user-friendly as possible, building the maximum consensus between the parties. The parties are encouraged at all stages to choose how the dispute is resolved. There are limitations on that, and what I shall come to in a minute, but as much as possible the parties keep control of the process. Privacy and confidentiality I have already mentioned. It's something which will take place away from a court setting and in a setting of the parties' choosing. And relative informality. Clearly it's not a mediation. The arbitrator will have to stand back from the parties, and unlike in a mediation where we would expect to call the mediator by his first name and the parties are all on first name terms, it won't be like that. But it will be much more like a business meeting than the sometimes hostile environment of a court setting, if you like, a sort of midway point between a mediation and a court hearing. Avoidance of court delays and standardisation. We think this is a major advantage for the clients. Court delays are legion. They are only going to get worse, particularly next year when the courts become flooded with litigants in person. By choosing arbitration, that is something you can effectively contract out of and have your own procedures and your own way in which you resolve the problem between the parties in as efficient a way as possible. Speed, we think it'll work quicker, but it's important to emphasise that it is not mediation and not part of the collaborative process. I've been asked, certainly by Jason Evans and indeed somebody else as well, how this fits in with the collaborative system, which some of you will be familiar with and some of you may operate. Because of course if you agree to go down the collaborative route in family law and that does not lead to a solution, the solicitors on either side have to drop out of the case. At the moment, there is no impediment to moving from a failed collaboration to an arbitration. I say at the moment because I actually raised this with the Institute of Family Law arbitrators and they've gone off into a huddle to think about it. But at the moment it's not banned, so it could mean that a failed collaborative process would then move on to an arbitration. I suspect they will change the rules on that, but they haven't yet. Finally, what do the parties want? They want a binding decision. Well, unlike a mediation, a family law arbitration will lead to a binding decision. I say will within limits. To this extent, there will be a binding arbitrarial decision. The judges in the family division have been fully kept into the loop on this, and they expect that what will happen is at the end of a family law arbitration, a decision is made, and if somebody doesn't like it, the other party will go along to the court, counsel will stand up and say, "Good morning, my lord, this is an IFLA case," and the judge will say, "Right, thank you very much indeed, and is there any reason why I shouldn't make the order?" There will have to be a good reason not to uphold a family arbitration decision. So the expectation is that the decision of the arbitrator will be binding because the parties have consented to it and have contracted into it. So to that extent, there's a very significant advantage over and above the mediation process. Right, let's look at the IFLA scheme. The Institute of Family Law Arbitrators. This is administered by resolution on behalf of IFLA, which is a company limited by guarantee. All the members are chartered arbitrators, MCI-ARB, and members of Resolution and Family Law Bar Association. To get to where we are, Simon and I spent a long and very arduous period in London, going through the training process, at the end of which was a difficult exam, which we obviously scraped through, otherwise we wouldn't be standing here before you. And the system operates under what are called the IFLA Rules 2012, which are on the IFLA website and will be on the College Chamber's website as well. It's important to make the point that English law is the only substantive, although not procedural, law. So we will only be dealing with English law, although, as in any other family case, if there are issues of foreign assets, for example, evidence might be received as to what would happen in another jurisdiction, but only English substantive law can be applied. It operates under the Arbitration Act 1996, which is a statute I have in my hand here. It's actually quite an easy to read statute, surprisingly enough, and it stood the test of time. It's in its original form, and we'll be going through it in a moment. And the scheme covers the following items: applications for financial orders following the breakdown of marriage or cohabitation, financial support for children, including Children Act claims, Inheritance Act claims, and Cellular claims. Those are the 4 areas that you'll be covering. So, a bit of substantive law. I'm going to skip through this reasonably quickly because we want you to stay awake and ask some questions and discuss it with us later. Section 1 of the Act sets out the objective of the Act, and it's really very simple. It's the fair resolution of a dispute by an impartial tribunal without unnecessary delay or expense. And the parties are free to agree how to resolve their dispute, and the court will not intervene unless necessary, effectively. So the parties will have to consent to it, and we'll come to how they do that in a moment. Section 2 of the Act is fundamental, and it deals with what's called the seat of the arbitration. And the seat of the arbitration will always be England and Wales, or it could be Southampton or Bournemouth, wherever it might be. But the first element of an arbitration is to establish the seat of the arbitration, because that gives the foundation to the decision. Section 4 of the Act and Schedule 1 sets out which provisions are mandatory and which are not. Some bits of the Act you can contract out of, and some you cannot. Some of the important ones that you can't contract out of are, for example, a stay of legal proceedings. So once a matter goes to an arbitration, proceedings are automatically stayed. You can't, I'm pleased to say, contract out of the liability for the arbitrator's fees, nor the Limitation Act, nor the immunity of the arbitrator. And you can't contract out of the general duty of the arbitrator, which, as you would expect, is to act fairly between the parties. And this may, I suppose, be an issue at some stage in the future if parties come to the arbitrator and say, well, we want you to arbitrate on this point, but not that. And we've reached an agreement on that, and the arbitrator says to himself, well, I don't think that's fair. We'll deal with that in a minute. Section 6 of the Act states that the foundation of the arbitration is agreement. It's a contractual relationship between the parties. Traditional arbitrations come about usually because there's a contract term between the parties. A JCT agreement, for example, will have a mandatory arbitration clause in it. Many IT contracts will have a mandatory arbitration clause in it. If a contract between commercial parties has that, as you know, you can't get out of it. You are stuck with an arbitration. Between people in family disputes, for example, an inheritance or a Cellular case, clearly there is no existing agreement between them. So a family law arbitration is an ad hoc arbitration, and that's why you have to contract in to the arbitration. And you do that by completing one of these forms, a form called IFLA 1, which sets out basic information, the parties' names and details, a brief summary of the nature of the dispute, and the fact that you wish to nominate either a panel member or an identified member of IFLA to arbitrate the dispute. And the way in which ARB1 works is that the parties who want to go to an arbitration must complete this form and must register it with the Institute of Family Law Arbitrators. And you can say, I would like Mr. Marshall or Mr. Lillington to arbitrate this case, or somebody else who is qualified to do so, or you can ask IFLA to nominate somebody on their panel, and the route to that is through our website and through the IFLA website. But the essential element is that this form has to be completed and has to be registered with IFLA. Section 9, which I mentioned briefly earlier, stays all other legal proceedings. So whilst the matter is in an arbitration, the parties can't go rushing off to the courts to try and do other things around the back, although, as we'll look at later on, the court may be involved sometimes peripherally to deal with matters such as what are called peremptory orders by the arbitrator, in which one party or other is in dispute. But as I say, arbitration is largely predicated upon the idea of consensus between the parties.
Sorry, you don't have to actually commence legal proceedings before
No,
you are...
You do not. You do not. No, you do not. That is exactly how it would work. In many occasions, it would simply come to the arbitrator and say, well, we have a client and another client, and they wish to resolve their matrimonial dispute. I mean, clearly, at the end of the day, any order of an arbitrator in family law proceedings between a husband and wife would need the approval of the court, so you'd need to go through that little level of it. But no, you don't, is the answer to that.
But that would be similar to sort of
similar to a mediation, exactly, or any other consensual arrangement between the parties. But you wouldn't, for example, need to start Cellular proceedings to do so, or Inheritance Act proceedings to do so. You simply come to the arbitrator filling in the form ARB1. We'll look at how it will be resolved within the arbitration with things like points of claim and so forth, but the answer is no to that. Section 33, duties of the arbitrator. Well, the arbitrator has to act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his or her case and dealing with that of his opponents, and adopt procedures suitable to the circumstances of the particular case, avoiding unnecessary delay or expense so as to provide a fair means for the resolution of the matters falling to be determined. That's the statutory obligation of the arbitrator, and essentially it is to act fairly between the parties and to adopt appropriate procedures, either by agreement between the parties or by direction of the arbitrator. I haven't mentioned it in the slide that you're looking at the moment, but there are powers in section 39 of the Act to make provisional awards, and section 40 of the Act requires the parties to do all those things to allow for the expeditious conduct of the arbitration. So again, the parties sign up to this process and they're under a duty to make it work. And indeed, why would they not want to? Because after all, they're paying for it as their way of resolving their dispute. Section 41 of the Act refers to the powers of the arbitrator to deal with parties who are in default. There are powers to deal with defaulting parties, for example, making an order dismissing the claim, continuing in the absence of the party, or making a peremptory order, in other words, a sort of unless order. Again, one would not expect that to happen other than very exceptionally, because the parties have agreed to have their dispute resolved in this way, and they have a duty to enable the arbitration to work in an expeditious way. However, Section 42 does have powers for peremptory orders and enforcement by the court, and in an extreme case, the arbitrator would authorise one of the parties to make an application to the court, and the court would make an order compelling, for example, the attendance of a witness or the preservation of property and so forth, because of course the arbitrator does not have the sort of wide interim powers of a High Court judge to freeze assets or to order inspection and so forth. It's part of the consensual process that these things happen. You give directions as an arbitrator, you expect the parties to comply with it, and again, why wouldn't they? Because they've signed up as a way of resolving the dispute. Under Section 47, the arbitrator has the power to make orders on different issues, and Section 52 is the arbitrator's final award. And effectively what the arbitrator will be doing at the end of the case, whether it's done on paper or by an oral hearing, is giving a judgment. And most parties, we expect, will want a reasoned judgment, although the parties could, if they wanted to, contract out of that and say, well, that's all very interesting, Mr. Arbitrator. All we want to know is what the decision is. Just tell us what's going to happen. We don't want to know why. We'll accept it. And if the parties choose to contract into that, it's their arbitration. They are able to do so, provided, of course, that the arbitrator is satisfied that he has acted fairly between the parties. So, these bits of the Act are mirrored in various parts of the IFLA rules. Article 2 of the IFLA rules, I have already mentioned to you the 4 main areas which will be dealt with in family law arbitration, and Article 3 makes it clear that the mandatory provision for English law applies, other law consistent with High Court practice. In other words, the arbitrator may, for example, receive evidence as to what French law will be on a particular subject, but obviously the arbitrator is not able to, and of course not qualified, to make any decision on French law. Article 4 deals with the appointment of the arbitrator, and as I've already mentioned, that will be, if you decide to come to College Chambers, via College Chambers, through the IFLA website as an alternative, and having completed the ARB1 form registering the case with IFLA. A next important thing, however, is the acceptance of appointment by the arbitrator. The arbitrator doesn't have to accept the appointment. Because again, it's a contractual relationship. It's hard to think why the arbitrator would not accept the appointment, but for an example that comes to mind is if the parties were to say, well, we want you to decide all the issues in this family finance case except pensions, because we've decided that the applicant is not going to claim a pension share, notwithstanding 30 years of marriage or civil partnership, and we don't think that that's going to be an issue. And you may, as the arbitrator, say, well, that's all very interesting, but I'm bound to take that into account when I consider the rest of the case. And the parties may say, well, actually, we don't want you to do that. We want you to completely ignore that, as if it didn't exist. Now, of course, contractually, the parties can say to the arbitrator, that's all we want you to decide. We're entitled to adopt procedures, the Act says so, the IFLA rules say so, and we only want you to decide this narrow issue and pretend that one didn't exist. The role of the arbitrator then is difficult in the sense that you have to choose, as arbitrator, between whether to accept the appointment or not. And I suspect that the arbitrator is likely to say, well, that's all very interesting, I can't accept that appointment at all, because all that's going to happen is I'm going to sit and listen to this case, make a decision, you'll take it off to the district judge, and he'll say I'm not going to approve it. And what's more, it wouldn't be right and it wouldn't be just. So the arbitrator has the opportunity to say, actually, no thanks, get somebody else to do this. And again, it comes back to my point about how this is consensus building. The parties try to meet as much as they can by agreement between themselves, and they contract into the arrangements that take place. Article 5 deals with the appointment of the arbitrator, and obviously the arbitrator can't act if there is a conflict of interest, and this really goes without saying. Importantly also, the arbitrator cannot act as a mediator. So once an arbitration starts, you couldn't say to the arbitrator, well, actually, we think we'd like to know what you'd do. We'd like you to try and guide us to a solution. That doesn't happen, it can't happen. What the arbitrator can say, and would be expected to say, is, well, I see that there's an issue over here in which you're not all that far apart, and obviously I haven't made a decision about this yet, and I haven't even heard the evidence or seen the papers, but you might want to think about this as a possible solution. And the arbitrator has the power, and with the agreement of the parties, will often, in these cases we suspect, say, well, why don't you go and discuss that element of it, break that away, because it looks as though there's a possibility here of agreeing that discrete issue. And then you may want to come back and have me resolve the other issues that you can't work out for yourself. So I suppose a sort of traditional indication from the judge, if you like, but not a mediation, not trying to lean on one side or the other. Hence, I made the point earlier, there are no FDRs in this. Communications with the parties are mutual. There's no private communication at all with the arbitrator. Anything that comes to the arbitrator from one side goes to the other side. Expressly forbidden to communicate ex parte, as it were, with the arbitrator. All communications open. This we think is going to be quite an important feature actually, because one of the elements of having an arbitration is that you do have pretty ready access to the arbitrator. So for example, directions may have been agreed at one stage or given by the arbitrator, and it turns out for some reason that those directions can't be complied with, or some new issue crops up which the parties can't reach agreement about. That's the sort of thing which will be resolved by a telephone directions hearing, a further telephone directions hearing with the arbitrator, in which a further discussion takes place to try to resolve that issue. And of course, one of the advantages we see in arbitration rather than the judicial process is that you may, for example, say, well, we're not going to be able to speak to you, Mr. Arbitrator, during office hours. Can we talk to you this evening? Can we do it by email? There's a degree of flexibility which there will be in the system which is not possible within the judicial system. Though I don't think either Simon or I will want to be too late at night with questions like that, but within reason. Okay. Article 7 sets out that the arbitrator has all the powers of a judge of the High Court, apart from injunctions, committals and powers over third parties. That's a pity, isn't it? We can't commit people. To digress, I remember once when I was doing crime in front of His Honour Judge Starforth Hill, and my client pleaded guilty for the umpteenth time, and the judge leaned over at him and said, I think I've seen everything on your record which English law allows me to impose upon you, apart from probation and death. And since I'm not allowed to pass the death penalty for taking a motor car, I suppose it better be probation. So death penalty, that's definitely out. There is an important issue in here, though, which is third parties. Will not have the power to join against their will, certainly, third parties who are involved in, say, business relationships between parties in family cases, though they may wish to consent. That might be a different matter altogether. But that is not within the scheme, at least at the moment. The arbitrator has the power to award interest and to make provisional orders. Article 8 sets out the powers of the arbitrator with regard to procedures, and the arbitrator will have the power to direct the production of documents, appoint expert witnesses. This is an important difference with the court process. In an arbitration, the arbitrator appoints the expert witness. Obviously, the parties will pay for it, and the fee will have to go through the arbitrator, through college chambers, but the arbitrator will appoint the witnesses. Again, as much as possible, one would expect to build consensus between the parties as to who an expert witness is going to be. If consensus is not available, the arbitrator will say, well, I've seen all the possible expert witnesses and I'm going to appoint this one. And as I've already mentioned, this is back to back really with the Arbitration Act. Article 8 deals with the power to grant permission to apply to the court in support of peremptory orders. Article 9 is rather important because it deals with the form of procedure. Will the decision be made on paper or upon a hearing? The parties may, for example, agree that they don't want to have an oral hearing. They're perfectly happy to submit all the papers to the arbitrator and have a ruling from him based upon the documents before him. And that may well be appropriate in many cases, particularly obviously the simpler cases. We expect that not to happen all that much because the sort of cases that are likely to be appropriate for arbitration, there are likely to be contested issues of fact in which the parties will want to come along and have their evidence aired and bring their witnesses along. Article 10 again mirrors the Act. The general procedures to aim for agreement between the parties as to procedures, and sets out the powers of the arbitrator to set timetables for statements of case, exchange of documents, witness statements and expert reports. Article 10 is basically the general procedure in family arbitration. And it'll apply, for example, in trusts of land cases and Inheritance Act cases, in which the arbitrator will expect to, for example, direct points of claim, points of defence, points of reply. I'll come to the alternative procedure in a moment, but this is the general procedure which I'm talking about now. Again, as much as possible, the parties will build agreement between themselves as to how they're going to go about the procedures which will be adopted. The arbitrator will already have a general idea of what the case is about because the IFLA form will have set that out right at the outset of the case. Article 11 deals with applications for directions and meetings by telephone and in person, at which the case is effectively set up for the final hearing. We would expect these to be conducted around a table in chambers or in your office, possibly by phone. In a complicated case, unlikely, because there'll be a lot of documents being shuffled about and a lot of discussion. The directions hearing will be effectively a business meeting, and that's the aim of the procedure at this stage. Article 12, probably more familiar to those of you who do mainly husband and wife cases, because that's the procedure to be adopted by Form E. In answer to Louise's questions earlier, this takes up precisely your point: the parties may not have issued proceedings. So when the alternative procedure is adopted, the arbitrator will usually give directions in a case between a husband and wife for Form E's to be completed by the parties and for questions and reasoned objections to be raised. Again, the directions hearing is likely to be rather more extensive than an FDA in family law, because whilst the arbitrator will not be saying, I'm not going to allow this question, I'm not going to allow that question, as the district judge will be, he will also be seeking to build the case for its final hearing, and I'll come to what we'll be doing in directions hearing in a moment, but it will go further than an FDA hearing. On the other hand, because this is as much as possible a consensual approach, you won't find the arbitrator saying, you can't have that question, you can't have this question, because then there will be a good reason why the parties want those questions. Obviously, the arbitrator is likely to say, well, do you really want those questions? But it's the parties who are setting their own procedures here. Article 12 also deals with allowing time for negotiation on discrete issues and directions for lists of issues to be exchanged. I'll deal with that in a bit more detail in a minute when we talk about what's going to happen at one of these hearings. Article 13 deals with awards, and as I've already touched on, one would expect reasoned written decisions from the arbitrator, effectively a judgment. Just from recent experience, the exam which Simon and I had to do in London consisted of writing a judgment, having been presented with a rather large bundle of papers and materials and notes and so forth. So you would expect a reasoned decision. And there's a reason for this, if you think about it, because certainly in a case between husband and wife, the parties are going to have to go along and present it to a district judge and say, we've got an IFLA judgment here, please will you make an order in these terms? And the judge will want to know that someone's actually thought about it and has come to a decision based upon reason. Article 14 deals with costs. The ordinary rule will be that each party bears their own costs. There is scope within the rules for a different order for costs to be made, but essentially an order for costs against one side or the other will only normally be made if someone's been litigation unreasonable. They push the costs up by non-disclosure, for example. The basic rule will be everyone bears their own costs. Article 15 deals with the conclusion of the arbitration. Article 6, I needn't deal with this in much detail, deals with confidentiality. Clearly it's a confidential process. So if we could spread on to a happy, cheerful family at the beach, how directions hearing will normally work. This is the point at which the parties set the arbitration in train. In addition to the directions that you would normally expect to hear at an early stage of a case, for example, questionnaires and Form Es, and it may be a case actually where the parties haven't got as far as issuing any proceedings, so the arbitrator will give directions for points of claim and points of defence. In addition to that, at a directions hearing, we would expect the parties to try to agree what issues they want the arbitrator to resolve. And the aim is to focus on resolution of issues at an early stage so that the parties don't go wasting a lot of money herring after issues that really aren't very important or which are going to cost them disproportionate sums of money. So you can expect a fairly rigorous discussion at an early stage with the arbitrator asking the parties, well, what really are you arguing about? Let's get this down on paper. What actually divides you? Let's make a list of these things. Now the parties, if they want to argue some harebrained point, are perfectly entitled to do so. They're paying for it. But the object is to focus minds on what is really important between the parties at an early stage. Finally, how will a final hearing normally work? Well, if it's done by way of an oral hearing, evidence will be taken on oath. If the parties want it, the proceedings will be recorded. We don't expect that will happen normally because there will be an expense involved. Witnesses will attend in accordance with their witness statements, and it will proceed in a similar way to a court hearing, except that it will be in a slightly more relaxed environment, in an office or a hotel room, without the hullabaloo of the court corridors going on outside. So, that's a quick skip through the Arbitration Act and the IFLA rules, taken at a bit of a pace, and Simon's going to talk to you a little bit further.
Thank you, Derek. I think I've done quite well because Derek's actually covered all the things I was supposed to cover as well, so I needn't keep you very much longer. Arbitration is obviously the next stage in the various processes to provide alternative forms of dispute resolution for litigants. If we go back to 1996, Lord Woolf, if you remember him, published a report called Access to Justice. And one of the things he said in that report was that litigation should be a last resort. Now, in those days, there was no concept of family law arbitration. Normal arbitration, commercial arbitration, has been around for centuries, but it was always thought family law arbitration was unsuitable, much in the same way as it was thought that the public having direct access to barristers was unsuitable. But of course that has gone now as well, and the concept of conditional fee agreements and so on have come and gone, waxed and waned in terms of popularity. The result of Lord Woolf's comments in 1996 really led to the growth in the promotion of mediation. And do we have any qualified mediators here? Good. Any qualified arbitrators? No. Okay. If you go back to the late 90s, you will see that there was an almost evangelical belief that mediation would prove to be the panacea for resolving all family disputes, and that it was going to offer a lot of advantages that court proceedings didn't offer. And this belief came to be shared by courts, judges, government and government officials as well. Of course, if it had taken off, it would have led to a saving in court time and costs, and that was certainly part of the driver. Although mediation was promoted as well on the basis, of course, that it was more user-friendly, less formal, and allowed the parties a degree of autonomy. Various attempts were made to promote mediation. Judges at the Central London Court, for example, set up a pilot mediation scheme in 1996, but in the first few years they never got above 5% a year of cases that went to their mediation scheme through choice, despite the court heavily promoting it. That led to further belief by government that if only people knew about mediation, then they would use it. And that led to all sorts of publications. The Legal Services Commission, for example, published another number of documents. One of them headed Alternatives to Court. There was a national mediation helpline set up, and a website, the National ADR website, but still few people chose to use mediation. So there were further attempts, stronger attempts made to try to persuade people to go to mediation, and the courts joined in. and they started to penalise people in terms of cost orders if they hadn't gone to mediation or had refused to go to mediation. And the threat was held over litigants that if you don't go to mediation, then you may end up paying the other side's costs, whatever the outcome. And that was the trend until about 2004, when a case in the Court of Appeal called Halsey against Milton Keynes General NHS Trust said that refusing access to the courts by effectively forcing people to go to mediation was contrary to justice and a possible violation of their Article 6 rights under the European Convention. But a lot of judges still thought that it was a good idea to try to coerce people into mediation. The Master of the Rolls, Sir Anthony Clark, in 2008 said that he didn't like the Halsey judgment, and litigants were really like horses, and forcibly leading them to water would promote them to drink. But it seems to me, and I think a lot of people will probably share my view, mediation in family law hasn't been terribly successful. I'm a qualified mediator. The number of mediations I've done, very low compared to the expectations, and that seems to be fairly true across the board, across people I've spoken to. So we come to arbitration, a new concept. It's only been around for a very short period of time. Is it different? Yes, it is different. But is it going to be any more successful? I don't know. It will only be successful if people like you use it, because you see the clients, you've got to tell them, go to mediation or arbitration. You've got to make a choice. Arbitration will only take off if you think it's a good idea for your particular clients as an alternative to court. So arbitration, family arbitration, has only been about since the beginning of the year. The first courses for people to qualify as family law arbitrators took place, I believe, in January of this year, and there have been 2 or 3 courses since then, and there are, I think by now, about 200 or so people across the country who are qualified family arbitrators. There is a qualification. You have to have carried out 550 hours of family law work a year for the last 10 years to be able to even go on the course. You have to attend the course, which takes a couple of days, and then there's a written examination at the end of it. And if you pass, you become a member, or you are entitled to become a member of the Chartered Institute of Arbitrators and to conduct family arbitrations. That can be compared to mediation, of course, because anybody can mediate a family dispute. You don't have to be a qualified mediator. Anyone can hold themselves out as a mediator and conduct a mediation, but that's not the case with arbitration. And also, when I did the mediation course few years ago now, I was quite surprised to be told that it was entirely appropriate for people to qualify as mediators who had no concept, no idea of the law as it applied to family law. And a lot of the people on my course who were studying to qualify as family law mediators weren't lawyers at all. They were, some of them were social workers, police officers. And the assumption was that because of the very nature of mediation, they were able to direct the parties to the mediation towards an appropriate settlement, perhaps in an ancillary relief case, even though they didn't have a clue what the principles would be that a court would apply. And when I asked the question, well, how can that be appropriate? The answer was, well, it's not for the mediators to tell them what to do. The mediator's just there to facilitate them reaching their own agreement. And I suppose the theory is they go off and see their solicitors, and then they come back and they carry on negotiating further. So arbitrators are qualified. Mediators don't have to be qualified, although a lot of them are lawyers, of course. So arbitration is really the next generation of the attempts by the government to provide an alternative. So I just need to find my documents here. To provide an alternative to people for resolving their disputes. So, arbitration is a concept that's been familiar to civil lawyers for a long time, but it's probably completely unfamiliar to most of you, unless you have practiced civil or commercial law in the past. There are no statistics kept about the number of arbitrations that are taking place at any given time. Most arbitrations are commercial by nature, and many of them are international. London is known as an arbitration hub of the world, and people who enter into contracts, international contracts for carriage of goods by sea, for example, will frequently, in their contractual arrangements, stipulate that in the event of a dispute, an arbitration takes place, and that it takes place in London. The next biggest centre, I believe, is New York, and there are lots of things like charter parties and bills of lading which govern the relationships between merchants, will either usually provide for arbitration in London or New York. And in London there are probably hundreds of arbitrations taking place every day, and no one knows how many, no one knows what the outcomes are. But it's been around for a long, long time. The Arbitration Act 1996 is merely the last or the latest in a succession of acts which have been passed over the years to support arbitration. And the courts have been very supportive of arbitration historically. Judges, particularly in the commercial courts, the Admiralty Division, and the High Court in general, will be very protective of arbitrators. They apply the Arbitration Act rigorously, and they do all they can to support arbitrations by perhaps providing interlocutory relief where the arbitrator doesn't have the power to do so, or other protective measures as they are required during a case. So you really, as solicitors, seeing your clients, need to know enough about arbitration so you can make a decision whether it's appropriate for your particular clients, because it won't necessarily be appropriate for all cases, but it will be appropriate, I believe, for many cases. What are the advantages of it? Well, Derek's touched on a few. Privacy and confidentiality is important to many people. And of course, that is one of the reasons why arbitration in the civil and commercial context has been so popular, because it is private. And there's no reason why that shouldn't be the case with family disputes either. Of course, there is a degree of anonymity in family disputes, but you always run the risk that if your case goes to the Court of Appeal, then you will be named. And the Court of Appeal is very reluctant to ever refuse to name the appellants. You have to make a specific application. If your case is going to the Court of Appeal, you don't want it reported under the names, you just want initials. You have to apply to the Court of Appeal, and it's quite a high test and hurdle to get over to persuade them to do that. So there is a risk of publicity, and that can be avoided by arbitration, of course. The selection of the arbitrator. The selection of the arbitrator is entirely up to the parties. They have a clean sheet when it comes to choosing who's to be their arbitrator, as long as he's qualified and a member of the arbitration body. You can choose somebody who is suited to your particular type of case. So if you've got a money case, you can choose an arbitrator who practices in the money field, or if you're dealing with trusts of land, someone who has a property specialisation or background. And of course, you know particular barristers who practice, you know whether you like them or not, whether you think they're thorough or not, whether you think they'd be appropriate for a particular type of case or not. So you can bring that to bear, and you can come up with a list, or perhaps identify one person who you think would be appropriate. So you can't pick your judge, but you can pick your arbitrator. And there's little you can do to avoid a particular judge, or to get your case before a particular judge who you think might be good for your case. So you can avoid that. You can avoid that risk. It is, as Derek has said, flexible. Arbitration is designed to be flexible. It's designed to be speedy, and it's designed to be it's designed to give the parties to it what they like, what they want. You don't have to go and creep and crawl at the listing office to try and get a hearing 2 weeks before the date they've offered you, 6 months' time. You can make the arrangements with the arbitrator for the hearing to be very quick, very soon. And that is something that's an important part of the procedure. And it's a flexible procedure in terms also of the manner in which the case is conducted, as Derek has said. And you don't need to be represented at an arbitration by a lawyer. You can be represented by anybody. So there are no problems with rights of audience. You could have any person represent you that you wish. So, as Derek said, how do you start? Well, in commercial contracts, the commercial contract will probably contain an arbitration clause, which says that in the event of a dispute, you have to go to arbitration. If somebody has a dispute and they issue a court claim, the other side will rush off to court and seek a stay of the proceedings and say, look, you can't do this, you've agreed to go to arbitration, so that's what you have to do. There are some exceptions to that, they're very limited, but that's how it works in the civil field. So you commit yourself in advance to arbitration in most civil or commercial matters by signing a contract that contains an arbitration clause. Of course, that doesn't mean that that's the only way that you can get a civil or commercial case to arbitration. There could be simply an agreement after a dispute has arisen that, okay, we'll go to arbitration instead of going to court, and it can happen like that. With family cases, of course, there is no contract. There's the divorce, the marriage ceremony doesn't contain an arbitration clause, but it occurred to me, it occurred to me that that in future, if we're drafting prenuptial agreements or even separation agreements, there would be no reason why you could not include an arbitration clause in that, so that in the event of any future disputes, you were committed to go to arbitration. Also, I don't see why you couldn't put an arbitration clause in a consent order, actually, so that in the event of the necessity to revisit it, perhaps on a variation, you could...
I got that.
There we are. You're ahead of me. You could go to arbitration. As Derek said, the method of commencing the arbitration in the family context is through the form ARB1, R1, signed by the parties or their representatives, and that kicks it all off. The arbitration starts when the arbitrator accepts the appointment. He doesn't have to accept the appointment. There's no cab rank rule, there's no obligation. He can take it or leave it, and it's as simple as that. He can either be nominated by the parties or chosen by IFLA, and whichever way, there's still no obligation to accept it. The arbitrator is required to act fairly and impartially between the parties and to give each party a reasonable opportunity to put their case and to deal with that of their opponent. This is a reflection of the rules of natural justice, and this is embellished in section 33 of the Act, which Derek mentioned. There are two applicable rules of natural justice. The first is that the tribunal should be unbiased and disinterested, and the second is that each party should be given a fair hearing. And indeed, if there are question marks about impartiality, then that would justify the removal of the arbitrator, which can be done under the Act, an application to the court to remove the arbitrator by one of the parties. And if there is not a reasonable opportunity given during the arbitration of putting the case, then there is the potential of an appeal by the party who feels wronged. One of the fundamental principles of arbitration, and it's a popular word these days, a bit like proportionality became very popular a few years ago. The word now becoming popular is autonomy. Parties should have autonomy to decide how their disputes are dealt with, and that is a feature of arbitration, has been for a long, long time. And Section 1, subsection B of the Act says the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. And that gives the parties a good degree of freedom to decide how they want their particular dispute resolved, and they can actually stipulate the procedure to the arbitrator. They can say, we want you to deal with this dispute and we want you to do it. For example, we don't want a hearing, we just want to put in written submissions by letter form, or we want to put in skeleton argument each, whatever, or we want to come along for half an hour each. It's up to the parties. They can agree what they want and tell the arbitrator, this is how we want you to do it. It's only if they can't agree that the arbitrator will then decide for them the procedure that will be used during the arbitration. So autonomy is important.
I just want to ask about the actual final arbitration in terms of evidence.
Yeah.
Do you have evidence in
There's no right.
examination?
There is no right to an oral hearing. It's up to the parties to agree what they want to happen at the final hearing. As I said, it could be, it could follow the format of a traditional trial, if that's what they want.
It doesn't have to.
But it doesn't have to. There is flexibility not only in the direction stage, but in the final hearing stage as well.
What's the default position, Simon, if they don't agree?
Then the arbitrator agrees. The arbitrator imposes it.
And what's that likely to be?
It's up to him.
Con-
Whatever he thinks is appropriate.
Conversely, what happens if they get to the final hearing and they say, look, we're agreed on this, this and this, and what Derek was saying earlier, saying that we can actually reject these instructions if we say, oh, she doesn't want my pension, and we've been married 30 years. And if they say, no, actually, no, I really don't want his pension, and he says she doesn't want it, we agree this, we're obviously paying you to be our judge. How do you deal with it when you've been dealing with it all the way through and you get to the final hearing and they say, no, no, we've agreed on these issues, but we only want this one to
Well,
be
the issues
decided.
would have been identified at the first hearing and made clear then, so that shouldn't arise at the final hearing. If they've compromised some of those issues between the directions hearing and the final hearing,
That's what I meant.
then the arbitrator really have to live with it. I mean, it's always open to appeal if one party is subsequently dissatisfied, or only on a point of law, and there are very limited routes to appeal. But by that stage, no, it would be the arbitrator would have to deal with it. There is no FDR. Derek mentioned that. Of course, the reason is obvious, and the reason is that if the arbitrator deals with the directions hearing and he's going to deal with the final hearing, he can't have an FDR because he then would be barred from dealing with the final hearing. But, I'm talking about money cases only, of course, but there would seem to me to be no reason why, after the directions hearing, the equivalent of the FDA, there's no reason why the arbitration cannot be stayed and the parties could have a private FDR before another specialist barrister, probably. So you would go off to someone else and have a private FDR if you wanted to do that. And only if you didn't resolve the case then would it come back and the arbitration would continue before the arbitrator to the final hearing as envisaged. Of course, there will be many cases when parties don't want an FDR. They just want to save money and they want to have as few hearings as possible, in which case they'd be satisfied with the directions hearing and the final hearing. And you can avoid the directions hearing by, you can avoid the hearing, you can agree the directions, you have a telephone hearing, you can do it in correspondence with the arbitrator, so you may not have to actually attend. Rules about confidentiality. There's nothing in the Arbitration Act that actually says arbitration is confidential. Sometimes people assume that there is, but there isn't. But there is in the IFLA rules in Article 16 a general principle that the arbitration and its outcome is confidential, except insofar as disclosure may be necessary to challenge, implement, enforce or vary an award in relation to the applications to the court or as may be compelled by law. And similarly, the documents, statements, information will be held by the parties and the lawyers in confidence and used only for the purposes of the arbitration. The arbitrator does have powers, limited powers compared to a judge, but the court can step in and enforce the and assist the arbitration or support the arbitration as necessary. If you have to go to court, for example, if you want to get a freezing order halfway through the arbitration, someone's looks like they're going to dissipate the assets or something, then you would go to court, and the court can make orders to support the arbitration. The court you go to is either the High Court or the Central London County Court at the moment, not the local county court. But that may...
Does the same apply for interim PPs and things like that?
No, the arbitrator can award interim PPs, but he couldn't award, for example, an interim lump sum, because a judge can't award an interim lump sum, so the arbitrator couldn't either. But he can certainly award interim PPs. So that's that really. I mean, there are other things in the back of the document you've got there, which you can read at your leisure. Arbitration is not that dissimilar from court proceedings. It is adversarial, in the same way that going to court is adversarial. So it's not touchy-feely and tree-huggy like mediation, but it's not the same as litigation. You're not going to get a judge who's very judicial and giving you a hard time and so on. You're having someone deal with your case who is being paid to do so and should do so professionally and thoroughly and competently. Time will tell whether it is more successful than mediation has been. In 2008, Lord Justice Thorpe wrote a paper which was published in Family Law, and he said that it shouldn't be long before all financial disputes between divorcing couples would be the subject of compulsory arbitration. So that is probably reflective of the attitude of many of the judiciary and probably the government. Much as the government doesn't like spending money on assisting people to argue about contact in private law children cases through the legal aid scheme, I don't think the government likes the idea of providing judges to help people resolve their financial disputes on divorce, which the government thinks, I suspect, they should sort out themselves in a less judicial way. So it may well be that there won't be an alternative other than arbitration in due course, although of course that removes autonomy, which was the purpose of arbitration in the first place. I suspect that perhaps there won't be a total ban on going to court to resolve things like ancillary relief. It may well be that the very big money cases will always remain in the High Court, but it's going to be the lower cases that are going to be compulsorily arbitrated or mediated. So there we are. Thank you very much.